time on the hearing, different ways, the general approach for how the NEB does public hearings, how you can participate in that. And then I'm going to have Paul talk a little bit about construction, operation, and abandonment, a little bit of information for you about what that looks like. Then we'll end with the questions and answers. So we'll start out pretty general with who is the NEB. We're a federal regulator. We were set up in 1959 by the federal government to make decisions about energy-related matters. Prior to that, the provinces were responsible for all their, under the Constitution Act of Canada, the provinces are responsible for their own energy resources and to develop them as they see fit. And when they started to have, pipelines going from one province to another or from Canada to the US, there was some confusion about who was responsible for that. And so the NEB was created to, the different areas that we regulate are construction and operation of pipelines across provincial and international boundaries. So between Canada and the US, we would regulate those pipelines, whether they're gas, oil, or some commodity pipelines as well. We also regulate power lines that cross into the United States. We regulate import and export of oil and gas, so you need a import and export permission. We also regulate the tolls and tariffs that companies have to pay to use the pipelines. So someone who owns the pipeline charges the shippers who are transporting the oil or gas on that. There's a certain cost that they charge for that, so we regulate that financial piece. We're independent. We're an independent body, so that means that we're not influenced by the company or the government during our approval process. We're a quasi-judicial tribunal, which really means we operate like a court of record. And being a court of record, there's certain rules that we have to follow in our procedures. Our processes are designed to be transparent and fair. Some examples of this: the information that the board uses to make a decision, that information has to be put onto a public record. Everyone can see that information. We're not allowed to have private discussions with individuals. So we're not able to go and sit down with the company during the application stage and talk to them about their project. We have to do it in kind of public meetings, just the same as we're not supposed to sit down with individuals as well to talk about particular things. It has to be public and on the public record. But we can talk a lot about our processes and the different ways that you can participate in them. The National Energy Board, we have 9 permanent board members, and it's those board members who are making the decisions. So for this Enbridge Line 9B project, there will be 3 of those board members who are put on a panel, and those will be the members who make a decision. Those members are appointed for a 7-year term by the Governor and Council. We also have some temporary members that are appointed for 3-year periods. We have one head office, and that's located in Calgary. So all of our staff is in Calgary. We were originally in Ottawa, but in 1992 we moved out to Calgary. We have about 400 staff that have expertise on energy matters. So we have engineers and economists, environmental specialists, socioeconomic specialists, lawyers, a variety of staff. So I talked a bit about the different areas that we regulate in, and when we are regulating those pipelines across interprovincial or international boundaries, we consider 4 broad areas, I guess: safety and security, environmental protection, efficient energy structure, and so that one is more around the financial side of things. So making sure that the costs are appropriate, the financial aspects are appropriate, and the rights and interests of those impacted by a project. So that's more the social side, which includes public, landowners, Aboriginal people. And so when the board members are making decisions on a project, they need to consider these four aspects, and they weigh them and balance them and try and make a determination in the Canadian public interest. Here's a map, maybe a little bit difficult to see. Kind of shows the major pipelines that the board regulates in Canada. So a fair amount over on the west side in Alberta and British Columbia. Some kind of on the bottom southern part of Manitoba and Saskatchewan. This one here that goes over top of the Great Lakes is the Trans-Canada natural gas pipeline. Along southern Ontario here, there's Enbridge, there's a Trans-Northern Pipeline and Kinder Morgan Pipeline. All of those are oil pipelines that exist. And there's some pipelines on the east coast as well. Maritime's a Northeast Pipeline and Emera Brunswick Pipeline. So all of those pipelines are regulated by the National Energy Board. I talked a little bit at the beginning about our what we call the life cycle approach. So the different phases of a project where we have some oversight into what companies are doing in the energy sector. We, as I said, if a project is approved, and we can approve or deny a project, so we do have the authority to deny a project. There's then during construction, during operation, and during abandoned construction operation, we have inspectors and we have auditors. So again, tying back to those four pieces, whether it's safety and security or the environment, the rights and interests of people, we have inspectors and auditors that go out there. So I'll talk a bit about the planning phase and the hearing phase, and then I'll turn it over to Paul to talk a little bit more about the construction, operation, and abandonment phases. The one piece I'll mention here, we also have appropriate dispute resolution staff. So when there are conflicts or disputes between companies and individuals, we have some staff that's available to help out with those disputes. If something between those two parties you can't resolve, maybe perhaps having a third party involved, the National Energy Board can help facilitate that resolution. It's a voluntary service, so both parties have to be willing to participate in appropriate dispute resolution. So if an individual is interested but a company is not interested, then we can't force them to participate in this process. But it is available anytime. So whether that happens prior to a hearing or during a hearing, after a hearing, maybe it's about property access or land reclamation, restoration, those type of issues, the board does have staff available to help facilitate appropriate dispute resolution. So on the planning phase, the planning or pre-hearing, again, the company is the one who designs a project. It's their project. They're responsible for developing and looking at it. What do they need to do? The National Energy Board, we don't develop any projects. We don't support any projects. We don't propose any projects. We have a mandate that when a project is presented to it, we have to assess it and make a determination if it's in the Canadian public interest or not. So the company in the planning and design stage, they're looking at, we have something called the National Energy Board's filing manual that lays out our expectations. We have expectations for engineering aspects, for environmental aspects, socioeconomic matters, land matters, economic issues as well. So those expectations are out there. So when a company is looking at designing a project, they need to keep those expectations in mind, design their project in accordance with their expectations, and they need to conduct the appropriate studies. They need to go out and do the environmental assessments. They need to go out and do the engineering assessments. They need to consult with the appropriate people about their project. So all of this is going on often before we have any sense of what the project is. They're working on it, designing it, trying to decide if they want to move forward or not. At some point, the company will file something called a project description, which is really just a high level, here's the project that we're thinking, and give a really high level overview of some of the engineering aspects, some of the environmental aspects, some of the consultation, kind of a planning document that they're planning to file an official application. At this time, the National Energy Board would start looking at some of the engagement activities, so looking at explaining processes to the public, explaining our processes to Aboriginal communities. And then a company will file an application. So once they've felt they've done enough in the design phase, they've got a project they think will meet the National Energy Board's expectations. They've talked to enough people, they've done their consultations, they've done their studies, they'll file an application with the board. And then that will bring us to the hearing phase. Well, first, so before I get to that, I'll just talk a little bit about the Line 9B reversal and capacity expansion project. So this is the one that Enbridge has filed. They filed in November of 2012. I won't talk too much about it. A couple things though. I think everyone's aware, but they're asking for 3 specific things in their application. They want to reverse the pipeline from North Westover, Ontario to Montreal, Quebec. Currently it flows from Montreal down to North Westover, and they want to reverse that flow so it goes the other direction. They also want to increase the capacity of the entire Line 9, so from Sarnia all the way up to Montreal. They want to increase the capacity from 24,000 barrels a day to 300,000 barrels a day. And
24 or 240?
240, sorry about that.
Okay.
240,000 barrels a day to 300,000 barrels per day. With that increase in capacity, they're not asking to change their maximum operating pressure. So right now, the project as it's approved, there is a maximum operating pressure that's in place, and they've not asked to change that at all.
The pressure is?
Would it not require more pressure to push heavier crude?
I won't get into too much, but what they've said that they're adding a drag reducing agent to it, and so they don't need to increase the pressure that they're transporting it on. And they also want to, for the entire Line 9, so again from Sarnia all the way up to Montreal, they want to make some changes to their Line 9 tariff, which would allow the transportation of heavy crude. So right now they're not able to transport the heavy crude, so this would allow them all the way from Sarnia up to Montreal. So there's kind of the 3.
I just had a little technical question. The first one there, 9A, reverse it. So where's that pipeline just going from Montreal? Is that the only area it covers? Like where's it gonna, I assume it's coming from overseas or something going there, so where's it gonna come from if it goes the other way?
Yeah.
From out west, I'm sorry.
Oh, okay.
Yeah. So there was a phase 1 of the project that was from Sarnia to Westover that they reversed. There was a hearing, National Energy Board had a hearing.
Oh, so it used to go from there to Sarnia, now they go from Sarnia.
Yeah. Originally, I think when it was built in the 70s.
I was just wondering where.
So if I may clarify, that's Westover, that's near Toronto. That's basically Sarnia, Toronto. That's the section that's approved.
Yeah.
Well, where's it coming from to get to Sarnia?
Westover, nobody knows.
There's a variety of connections to Western Canada and Western US. So all the documents are available on the NEB's website. We have, there's a repository that has the application itself and also the supporting documents. So the environmental assessment that Enbridge did, the engineering assessment that Enbridge did, the consultation logs that document who they've consulted with and the issues that have been raised. All those documents are up on the NEB website, so you can look at those. It also tracks, maybe 2 weeks ago, about 2 weeks ago, we asked a series of questions. So we're, at the National Energy Board, there's a project working group who's looking at this project and seeing if they match up to what we have our expectations in the filing manual. And so 2 weeks ago, we asked a round of information requests. So we asked a whole bunch of questions to Enbridge. And Enbridge just recently responded. So you can see the questions we asked, you can see Enbridge's response on this website as well. Sure.
Is it a strange coincidence that was the same day that the EPA ordered them back to work?
Yes, strange coincidence. Yeah. So here's the map. So that, yeah, North Westover is just outside of Hamilton. And so they're reversing this portion here. Right now it flows from Montreal down to North Westover. So they're reversing that so it'll flow up to Montreal. And they're going to increase the capacity all the way from Sarnia to Montreal. The capacity on the entire line will increase. And the tariff, which is the rules or what they're allowed to ship, that will also be changed for the whole line.
From Montreal, kind of in the line of where does it come from? Where is it going?
In the application, I believe Enbridge has said that there's two, I'm not sure what the correct word is, but the commercial support for the project has come from a refinery in Montreal and a refinery outside of Quebec City. So that's to supporting the project. A couple key dates that we have. The hearing order, the national, so, yeah, and I'll talk about this a fair bit. I had a couple copies that have gone, and if you signed up, I'll make sure you get a link to this. We have, in February 19th, we sent out a hearing order, is what we call it. It's kind of a key procedural document for the National Energy Board. It kind of explains our process, what it is, what it looks like, some useful information for people who are interested. There's, a couple of important appendices. Number one talks about the list of issues, so the things that we're going to be able to talk about in the hearing. Talk about that a bit later. It also has a timetable of events, so it outlines the particular events, and it puts a deadline for those events as to when they're going to happen. Yes, sure.
I noticed March 21, the due date to make comment on the list of issues is missing from that list. And to correspond with that, I'm wondering, is there a revised list of issues coming?
Yep. So, there will, and it was, so you're right, I just put up some of the key ones, but I'll talk a bit to that. So last week on the 21st, we included in the hearing order was a list of issues, and there was an opportunity for people to comment if they had comments on the list of issues by the 21st of March, and many people did. And they are in the process of revising the list of issues to, to address people's concerns or not. And the board, the National Energy Board, will be releasing a procedural update, is what we call it, where we make some changes or modifications to the schedule, and that should come out this week. I
So they'll be
anticipate.
released before the deadline to apply?
Yeah. So the procedural update will include the revised list of issues, and it'll also include the application to participate form.
And those are being updated as well because of C-38? I understand there's some differences in the application
Yeah,
process?
for the application to participate
Yes.
process, that's been revised since Bill C-38, yes.
So those forms are actually available now?
They're not yet. I anticipate Thursday maybe?
So
So
there's
very
gonna be
soon.
some room there for people to absorb the revised list of issues before they have to decide how they want to participate?
Yeah, and I can't guarantee, but I'm pretty sure that this date will change as well, the application to participate.
That would be lovely,
It should change to the 18th or the 19th of April.
wonderful.
But that's still very tight, Michael.
Yeah.
Almost intentionally tight, I have to say. It seems that way at least.
It'd be nice to push it a little further, but
Yeah, I mean, I think they understand that it's hard and it's complicated and
it
people
has
have
to be
lots of questions.
realistic.
So I think they've agreed that there'll be at least 2 weeks. They'll make sure that people have at least 2 weeks to think about it and absorb it and articulate how they want to participate. And
Which is a lot less time than between the 19th of February and the 11th of April.
And I really have trouble seeing the reason for the short queues on this, because you're not doing hearing until the fall. But why the short time for people to get their act together to?
Well, and so there are, I've just put up the key steps, but in the hearing order, there are additional steps as well. So if you apply to participate as an intervener and you want to ask questions to Enbridge, you want to ask questions to other interveners, there are additional pieces as well. So it is, I think it's fair, it is fairly tight. I'll describe a little bit more as we go along. So these 2 dates, the July 9th for writing your letter of comment, if you want to participate by writing a letter of comment, or submitting your evidence if you want to participate as an intervener. Those are in July, but there's other steps, other written steps that are in advance of that. What's currently proposed is that at the end of August would be the oral portion of the hearing. It would be oral final argument, so people would have a chance the interveners would have an opportunity to stand in front of the panel and express their views, express their opinions, and try and convince the panel, you should make this decision for this reasons. This evidence should be given more weight, this other evidence should be given less weight. So that would happen at the end of August. And then the National Energy Board would close the hearing. The evidentiary portion of the hearing and then usually it takes us about 12 weeks. 12 weeks to write a decision. We provide reasons for our decisions. So it's not just yes or no, but we provide reasons. We kind of summarize what the evidence was heard, and so it takes about 12 weeks. So a decision on this would be out probably in the end of November. It's the rough, it gives you kind of some of the key dates for the hearing. One thing there is, I talked a little bit at the beginning, there were some questions that I thought Enbridge might be better suited to answer. They do have a project-specific website set up that has some details available on that website. They have a project-specific phone number and an email address. So if you do have some concerns, sounds like lots of people have been in contact with Enbridge. They're also a source of information, and it is their project. So they do have a responsibility to inform the public about their project, consult with the public, to identify some issues and concerns. And they also have the responsibility to modify their plans to mitigate public concerns where appropriate. So a lot of times, as a process advisor, one of the first steps, in my view anyway, is where lots of times it's to contact Enbridge to see if, what your concerns are, raise them with Enbridge. Does Enbridge do a good job of addressing your concerns? If yes, well then that's fairly straightforward. And if they don't, then look at using the NEB's process to try and address those concerns. If you're not satisfied with the response that Enbridge's given you, or you want them to do more, then you should be looking at, well, maybe is the NEB the right place to try and get these concerns addressed?
Quickly, sorry, Michael.
Yeah.
Is that consideration a criteria that you use to evaluate the appropriateness of applications to participate, whether people have inquired to Enbridge or not?
In the application to participate.
In hearing processes, like is that what you just described, the encouragement to contact the company directly, is that a criteria that you evaluate potential applicants to participate in hearing processes?
No.
Okay.
That's not a consideration when we're reviewing who can participate in our process. We don't look at that.
Is there an appeal process after the NEB makes a decision people disagree with, or the company disagree with?
For the NEB's
Yeah, is
decision?
the decision final, or is there an appeal process after?
There is a potential to review the NEB's decisions, but I think generally they're reviewable on errors in law. So if we make mistakes, and if we don't follow our process, we don't follow our mandate, those type of decisions are appealable.
Oh.
I think it's really difficult to appeal a decision, or review a decision. They didn't get the right balance of factors. I think that's really tricky, but they can be if there's errors in law.
And would you go back to the NEB, there'd be the people you appeal to, or would you go through the courts?
I think it's through the courts.
There's an initial appeal to the NEB, and then if that doesn't work, you can go to the federal court of Canada.
And it has to be done within 30 days of the decision being released.
Okay.
Well, I've just finished reading some testimony from landowners associations, including a presentation they just made to the Senate committee. And what I understood from what they wrote was that the courts are closed to them. That the NEB, they have tried, and they are told that when it comes to pipeline issues, NEB is it. And that's why it's structured as a quasi-judicial thing. And that you can't take an NEB decision and take it to the courts. That's what I understood.
Yeah, except I think on those errors, again, the errors in law, but I think a lot of times when they're looking for appeal is more did you find the right balance?
Right.
And so those, I don't think they can take those ones. Yeah?
What criteria would be used to determine intervener status?
We'll get there. We'll get there. I'll just talk a little bit in general about the hearing process. So typically, this is our general process. We talked about how the project description is filed. That's that general overview of what the project is. And on this particular project, Enbridge filed that in October 11th, 2012. Usually that triggers our own engagement and our participant funding program. In this particular case, the section of the act that they filed the project under, there's not 40 kilometers of new pipeline that's required. So the board doesn't legally have to have any type of public process. A lot of times if it's a meter station or something really small, the board will have a comment period and do the assessment, but not necessarily a public hearing. So there was some uncertainty here if we were going to have a public hearing or not, because we weren't mandated to have one. And so our engagement and participating funding, we waited until the application was filed in this case. And the application was filed in November 29th, 2012. And given the level of interest in the area, and we had the Enbridge the Line 9B Phase 1 project, there was a lot of interest in that, and we anticipated lots of interest in this one as well. So the board members decided to have a public hearing process. And so that kind of triggered our own engagement and launching of our participant funding program.
Sorry, the Line 9A project that is on, what was its timeline? Was that applied and went through? Did it have a public process? Or?
Yeah, it did have, and again, because what they had filed under, they weren't required to have a public hearing process. We had our standard letter of comment process, and there was a lot of letters of comments, and then they eventually made the determination to have a public hearing process. So they had it fairly similar to this, where they had, people were able to participate, and they had a written process, and then they had a final oral portion as well.
Do you remember how long that was, when they applied and then the decision was made to approve it?
I know the decision came out, I think it was about last summer. I would guess June, maybe June 2012. I'm not sure exactly when they applied. That is available, again, on our website. When you look, you can look at all the documents from the Phase 1 portion, and so it can give you a sense. And maybe afterwards, if you want, I can bring it up and find that here for you.
What section of pipe did that line be?
So it was the portion from Sarnia to Westover. So again, they weren't constructing any new pipeline, but they did have to do work in the meter stations to reverse the flow. Yeah, so in this part, so we have issued the hearing order. That was in February 19th. And so in this portion, again, very similar to Phase 1, there will be a written portion where interveners will be able to put forward evidence. They'll be able to ask questions of Enbridge. They'll be able to ask questions of other interveners. So there's a fair bit of written portion. And then there'll be a final argument portion, which will be oral. So again, that'll be the last week in August. The board has flexibility to have this oral portion where there's interest. So if there's a whole bunch of interveners in Toronto and a bunch in Kingston and a bunch in Montreal, then the board might look at having, a couple days in each location. So there is some flexibility where the oral hearing will happen. As I said, when the board finishes argument, the evidentiary portion closes, and then the board has to look at all the evidence that's been submitted, and they make a decision based on the evidence that they have on the record. And that decision comes out about 12 weeks afterwards. So I'll get into a little bit now about the different participation options that are available. Right now, the deadline is April 11th, and I don't know, 95% sure that that's going to change. That information, that'll be confirmed this week when the procedural update comes out. So that'll include the revised list of issues, the application to participate form, and it'll also have the date of when the deadline is to apply to participate. So I'm pretty confident it'll change. Hopefully it will. The application to participate form, there'll be a couple portions of that. I mean, the key things here on when you're applying to participate, there's two factors that the board's going to look at. You must describe how you'll be directly affected by the project and/or how you have relevant information or expertise. So these are the two factors that the board looks at when determining who can participate in a process. And as Sherry was mentioning, this is a new section of the Act that has just come out in response to the Bill C-38. So we don't have, just
Sorry, it is different from 9A, correct?
yeah. And so typically, this will be a decision that the board members are making. They'll be looking at who's applied to participate and making a determination who is able to participate. And every time the different board members will make different decisions, but often it's helpful to point to previous decisions to give you an idea of who has been allowed to participate or who has not been allowed to participate. But unfortunately here, because it's new to our Act, we don't have any previous decisions that we can point to. So it's a little bit unfortunate that way. A couple of things I'll say though is, the form, when it becomes available, hopefully it should be this week, it's going to be really important to fill out the form completely, because the board members are only going to use the information that's included in those forms to make their decision. They're not going to, they're not going to go back and clarify with you, oh, you said this, did you mean this, or did you mean that? They're only going to look at the information that you provide in those forms. So you have to make sure you have the sufficient information in there.
Michael, this is a question.
Sure.
Yeah, relevant information. There's so much standing information against Enbridge in the public domain already. Is that they're not just looking for what's already been in the paper. They must be limiting their criteria to something that you know above or below. So to me, that's going to go right to the paper.
Well, so in the hearing order, there's a little bit more guidance in Appendix 6 of the hearing order that talks about, what do we mean what does the board mean when we talk about directly affected persons or relevant information or expertise? And, with relevant information, they talk about, the source of that person's knowledge, and they talk about local knowledge, or regional knowledge, or Aboriginal knowledge. So something like local knowledge, that can be very relevant for the board making a decision. They don't have, if the board members are not from the local area, they, how else do they know about the area? Maybe there's certain things that are important to them. So to me, that type of thing, that opens it up to people who have local knowledge about the area that might be relevant. So I don't know if that helps a little bit.
Yeah, it's just that they narrow the scope of this to the point where it appears to me that they're not going to consider 80% of the relevant information, like the company's performance in the past so far as Kalamazoo. That's not going to enter into the deliberations. It's going to be how much somebody from Trenton knows about where the line crosses the Trent River, which of course the company's going to assure one say.
Yeah, and again, because we don't have any, the board's never made these type of decisions before. I don't have any good previous decisions that I can agree with you or disagree in terms of how they're going to make their decisions. So in my mind, you have to look at the guidance that they've given and make a case for that. So they talk about relevant information or regional, like local knowledge or regional knowledge. And I think one thing they'll be looking at is tying that back into the list of issues. About, is it engineering issues that you're concerned about, emergency response, or environmental effects, but making sure it relates back to the project. And yeah.
Can I attempt to interpret it?
You sure
in
can.
a way that might be helpful. I think in some ways our role here is to take this language that's been given to us of directly affected relevant information and expertise, and to rather than maybe put so much pressure or put pressure on Michael to maybe explain what it means, maybe take the time to work on it collectively and find ways that we fit into all of those categories. And I know it's possible, everyone who is interested in this has, like, in some way, time and resources to get together, and the existing groups should probably take the time to help each other interpret what this means, rather than worrying about whether it makes complete sense right now. That's what I'm saying.
That makes sense.
It does? Okay, good, thank you.
Because,
Especially given that this is the first time the board is doing that, would the board be required to give the reasons for refusing the status to some applications, and would the applicant have the opportunity to let's say, review his application if refused, the status?
I think all of the board's decisions can be reviewed. So I think there's always an opportunity for
But
that.
would the board first give the reasons why it chose not to approve certain applications? Like, would the applicant know why?
Yeah, and I'm not sure if they, again, because we haven't seen exactly what it's going to look like, I'm not sure. I would imagine they would.
I'll just illustrate, when you apply for some grant and so on, typically if you're refused, you're given some reviewers without names, but you're given reviewers' comments and so on, on which basis you have been refused. So, similar situation.
Excuse me, Michael, can I just add something to that?
Sure.
One comment there? I do apologize if I appear to be putting you on the spot. However, part of your job here and part of our job here is to ensure that this process is going to be thorough and complete. And that's what my question was pointing at.
Oh, don't. I'm not offended at all by your questions. Like, I'm here. If I can't answer, if you ask a tough question, then I'll have that answer.
Or legit.
Yeah. But yeah, I'm not 100% sure if they are. I would imagine that if the decision is not to grant everyone the participation that they wanted, there would be some type of explanation. But again, we haven't seen that yet. So yes.
Is this the first time that Enbridge, or even a pipeline, has had the flow reversed? Because we're going from gas one way to practically solids another way.
Yeah.
Well, a hot solid to a gather, they have to heat it in order to make it move. It's not a very attractive stuff that we have to move, but has this ever been done before? And if it hasn't, then I would think the board would be only too glad to make a thorough study of the whole thing and allow for as much participation as we can find from people.
So a couple points on your questions. In this particular application, right now there is oil that's flowing in the pipeline. So it's oil that's flowing from Montreal down to Sarnia. So it's not a natural gas pipeline. It's oil right now, and so they're going to reverse the flow of oil. So it'll still be oil afterwards. And they're asking, and one of the requests that they have in their application is to be allowed to transport heavier oil, heavy crude, which right now they're not allowed to do. But so it is oil currently, and it will be oil in the future.
But it's not the heavy, unprocessed.
Yeah.
It's got these additions.
Yeah, and so then on reversals, has the board seen reversals before? Yes, we have seen reversals before. We've seen reversals on gas pipelines and oil pipelines. We've also seen conversions from gas pipelines to oil pipelines. So we have done that. So there have been these different permutations and combinations.
They should call this a re-reversal because line 9 was reversed in 1999.
Yeah, yeah. I think Enbridge actually sometimes they call it the re-reversal.
Just to clarify, if you're confused about the gas line versus the oil line, you're not alone. Nobody in Glenburn even knew that the oil pipeline was there. It is so poorly signed, it is not anyone's fault. So yes, you're very aware of the Trans-Canada gas pipeline, but laying right beside it, just to the south of it, within arm's length is the Enbridge oil pipeline. And you'd have to look hard to find it, but it's there. Yeah, no
Because we
problem.
have had gas leaks along there,
Yeah, and that's a Trans-Canada gas. Yes. So, and the other thing is, I believe that Arkansas was actually a reversal.
Okay, I'm not sure.
That went back
So here, the board will decide who can participate and how you can participate. And so the two options for the Enbridge Line 9 phase, the Line 9B, there's two options to participate. One is writing a letter of comment, and the other one is participating as an intervener. I'll talk about those in a second. You can also, I think when we were going around the room, there was some interest in how do we know what's going on and how can we track that. The review process, the public hearing process, it is open to the public. You're able to monitor the board's website, the public registry. This is where all the information is, so it'll continue to be there and it'll continue to be updated as we go along. During the oral portion of the hearing, you can come and watch. Those are open to the public. You can come and watch that. We also have transcripts that are available, so you can follow what people are saying. You can listen to it on the board's website as well. So there's some options. If you're interested, but maybe you don't want to devote the time or effort, but you want to kind of follow along and be in tune with it, what's going on, there's some options there. The first one I'll talk about is, so if you're interested in getting more involved, the two options are letter of comment writing and the intervener. The letter of comment is...
Excuse me, just a question.
Sure.
You say the methods of interaction include a letter of comment and intervener. Are these the two only, or there are other ways of participation?
These are the two.
Okay, so it's not include, they are. Okay.
Well, technically,
Yes.
I guess if you
Okay.
were an Aboriginal participant and you weren't comfortable in participating as a letter of comment, there would probably be some flexibility
Okay.
to accommodate some Aboriginal elders.
Okay.
That's the include. Sharp eye. So the letter of comment writer, this is kind of the, just from, it's a step up from monitoring it, but it's still a rather kind of an informal way to be involved. It is, this type of option allows you to share your views and opinions on the project. It's a letter of comment, but included in that letter, it's not just a letter. You can put in such things as technical reports, articles, maps, pictures, survey results, so you can support your letter with whatever type of information you think would be compelling or convincing for the board members. You can also put in your letter, terms and conditions that you think should be applied in case the project is approved. So things that you might want to see Enbridge have to do. The letter of comment, it should be related again to the list of issues, so related back to the project. The letter of comment, you can participate this way. You don't have to attend the oral portion of the hearing. You don't have to track all the written portion either. What you do need to do is write your letter, the deadline for that. So you have to apply to participate, currently the 11th of April, and then you have to write your letter by the 9th of July. The letter of comments, they'll be posted on the board's websites, so they're public documents, so everyone can see them. The panel as well, they read all those letters of comment, so it's access to the decision makers to make sure your views are known, views and opinions are known. The other option to participate is as an intervener. This is kind of the most involved way. This gives you access to the most rights in our public hearing process. The board, if you are given the right to participate as an intervener, you can file evidence supporting your position. You can ask questions. You can ask questions to Enbridge. You can ask questions to other interveners as well. You also are responsible if you submit evidence. You then have to. So if Enbridge asks questions about your evidence, you have to answer those questions. Or if other interveners ask questions about your evidence, you're responsible for answering that. You can participate in the oral hearing, so in this case it would be giving oral final argument. So again, that's the opportunity for you to convince the panel, what do you think is the right decision and why is that? Maybe say this evidence should be given less weight, this evidence should be given more weight, and try and make a compelling statement to the to the board members. Yeah. To be an intervener, it does require time and resources. For this reason, we encourage people who have similar interests to intervene together. So if you can, get together as a group, if your interests align, that might be one way to facilitate, make it a little bit easier. Interveners are eligible for participant funding. So if you write a letter of comment, you're not eligible for intervener funding or for participant funding. It's only accessible to interveners. And we'll talk maybe now about the participant funding.
Michael?
Yeah.
Sorry.
That's good.
One question running around my head is, have they decided where they're going to hold the process?
No.
No?
So again, that'll largely be determined. There's flexibility. And
I'm
so
just
it'll-
thinking we're kind of halfway.
Yeah. So it'll largely be determined where there's interest and where there's interveners.
Which is going to be Toronto at this point, right?
Well,
Okay,
I
they're
don't know.
the biggest dog in the whole thing.
but it's more about the interveners
Yes.
who participate, and the board looks at trying. Well, it'll be. Yeah. So if there's 90 people intervening from Kingston and no one else, they would just have the hearing here.
Okay, the other thing is the letter of comment is sort of outside of the final process. It's not actual evidence, it's not considered evidence in the final decision.
Good question. It is evidence, but it's not tested. So Enbridge doesn't have the opportunity to ask you questions about it, or other interveners don't have the opportunity to ask you questions about it. So it might not carry as much weight as if you put that forward as an intervener.
And do interveners have an opportunity to cross-examine Enbridge's input?
Yep.
Yes?
Yep. And again, so it's in this process, the cross-examination it's a written process. So through asking information requests. So.
And it's sort of moderate for you?
No, it's not moderate. But the board establishes here's when you can ask the questions, and then we don't filter or we don't look at the questions or edit them.
They all do go on your website.
Yeah, so it'll be public. So you'll be able to see, even if you're not an intervener, all the interveners' IRs will be on the website, and everyone can see that, and they'll be able to see the response from Enbridge to those IRs.
Can you apply to be an intervener as well as write a letter of comment in the case that you're denied to be an intervener?
Oh, if you were,
If you were,
I would pick which one you're interested in. If you're more interested in participating as an intervener, the board, I don't think they wouldn't. If you applied as an intervener, they wouldn't not let you participate at all. I think you would just not be allowed to participate as an intervener if they weren't convinced. They'd say you can participate by writing a letter of comment. So you wouldn't have to apply to participate both ways to preserve that space. I think you just apply as an intervener.
Are there fees associated with submitting a letter of comment or being an intervener?
Well, the letter of comment, there's probably a 55-cent postage stamp fee. But no, there's no fees for participating in any way. And you don't, as an intervener, you don't need legal counsel, you don't need legal representation. We try, and part of my role as a process advisor is to help people understand the process and what they need to do and how they participate. So for interveners to get in, we would be giving kind of targeted workshops for, now it's, maybe we provide one on, it's time to submit your evidence. So we do a little workshop a couple weeks advance in the deadline of what does it mean to prepare evidence? What does evidence look like? The deadline for, now it's your turn, intervener's turn to ask information request questions to Enbridge. We'd probably have a workshop on how do you draft information requests? What do they look like? What should you think about? How do you phrase your questions? What the format is? So there's help for people who are interested in participating that find it a bit confusing or
there's a whole big premise, but since there's a participant funding
funds available from the NEB, I would assume that the NEB, apologize for my voice, would have some sort of expectation as to how much it would cost an intervener to participate in this fund process. Do you have any idea of how much that estimate is at the present?
We'll get there.
Oh, okay.
I might answer, but generally, it's up to, when you're applying for participant funding, you make a case for what you think you need. And so, depending on what you're interested in doing, is it writing reports, is it getting some experts to review some reports, is it just attending the hearing, is it working with other groups to facilitate? It really depends on what you wanna do, what you wanna present. I mean, I was just gonna say, sometimes it's as simple as, I wanna attend the hearing, so I want my travel costs covered. And so then, it's, they happen to live 30 kilometers away and have to stay in a hotel room. And so we can get requests that are quite simple that way. Here's the funding that I need. Where others are far more complicated, where they're looking at doing studies and research and hiring lawyers and all sorts of things. So there's a really big range.
Is there any way for a group to get an estimate, or say a municipality who's not eligible under the participant funding? Is there any way for them to get affirmative, more detailed information? I understand that the city staff of the city of Kingston did a thorough job in estimating the cost between $100,000 and $200,000, which a lot of groups think is a lot more than what it would cost the municipality to participate. So I just didn't know if the NEB was able to sort of give any type of numbers to help municipalities have a more clear idea on how much it costs.
Yeah, I'm not sure about that one. We do have a participant funding coordinator that might be able to maybe at least give you a ballpark of what some of the previous costs have been to participate. Maybe I can follow up with you afterwards.
Sounds great. Thanks.
Yeah.
Is there someone at the NEB, you talked about the consultation process before for the interveners. Is there someone at the NEB that will review intervener submissions beforehand, just to make sure that people don't get in trouble and say something that the company can come back on it later?
When you're applying to participate?
No, when the participants prepare their presentations, is there someone that can look at it and say, gee, you really shouldn't say this because they could come back on you for libel, for example? Companies are known to do this. Surprisingly.
Yeah. As a process advisor, my role is to try and help you out. I wouldn't feel that's kind of beyond my, I don't review it from a legal perspective. I generally don't get into, I'm not trying to make the case for you, but I try to help you understand what your options are and how you could, but I wouldn't actually get into the case of how you should best frame it or best make your case.
So probably then an intervener should have a lawyer. For sure.
That's what you want to say.
So it is available, the participant funding program. It's available for individuals, landowners, Aboriginal groups, not-for-profit organizations, and other affected groups. The one catch, we talked a little about this, if you apply for funding, you must also apply for and be accepted as an intervener. If you're not accepted as an intervener, you're not going to be eligible for the participant funding. Funding amount determined for each project, and it depends on things like potential impacts of the project, size, location of the project, and diversity of issues. So they kind of calculate how much they think they're going to need for participant funding, set aside an envelope. I think the program was designed not to cover all expenses interveners may incur, but because of that, we encourage people with similar interests to try and collectively work together.
Can I stop you just before you click that? Completely unrelated, I just want to come back to it. That picture is exactly what we see with new homes built. That's a high-pressure transmission pipeline, way too close. And I guess I'd like to know what the NEB, or who on earth is responsible, whether it's the city, the municipalities, somebody should not be allowing that to occur. But anyways, go ahead, I just wanted to bring that up.
Yeah, and Paul, you might get to that in your...
I'll give it a shot right away. First of all, the company can only control what's on its right of way.
Yeah.
Outside of the right of way, it's in the control of the landowner and through zoning municipalities. The company can only complain, point out that it's too close, identify how far you'd have to be, so if this thing, the worst case scenario, blew up, you know, things like that, but they don't really have any kind of ability to control what's going on outside of that right of way.
The company doesn't.
The company doesn't.
No, I understand.
There's a safety zone that's been established at 100 feet, I believe, past the right of way, and that's kind of a call before you date kind of scenario, so that if somebody's using power equipment or explosives, they have to contact the company so they can check out their plan to make sure that's not going to damage the pipeline. But other than that, it's really the landowner. If the landowner wants to develop his property and put all those homes there, the company has very, very limited.
No, I would fault the company. I would fault agencies which are responsible for public safety, which on interprovincial pipelines is you folks. But again, I know it's completely
So
separate.
we regulate the pipeline, we don't regulate all that other stuff. That's more of a municipal thing.
So then who is responsible for public safety in a situation where it's, if you've got a 1200 PSI line with gasoline in that close to people's bedrooms, I mean, anyone would say it's not safe.
We haven't made it closer, but
Exactly.
but it's typically a municipal issue and those people, planners.
Okay, fair enough.
So the funding, it can be used for all sorts of things, as we were talking. It's up to the person who's applying for participant funding, which is a separate application from the application to participate. It's up to the person to decide what it is they want the funding for. You can use it for reviewing the application, so reviewing the environmental assessment or the engineering assessment, reviewing evidence from other interveners, preparing your own evidence, preparing information requests. It could be travel expenses for a hearing, you know, coordination or collaboration with others that have similar interests. So it's really, it's kind of up to, for the participant funding model, it's, you know, you have to design what type of funding you'd like to have, and it's pretty flexible in terms of what it'll be, what it can cover. The application for participant funding, it's open till July 26, 2013. But really, if you're interested in this, you should be applying as soon as possible. You can apply now. That type of information is on our website. The application to participant form is on our website. It's open and available. I would encourage anyone who has questions, you can talk to me about that. You know, the process is you put in your application to participate, and there's an independent review committee that looks at all they recommend the participant funding amount, and they make decisions on who gets awarded the participant funding program. This committee is made up of, I think it's usually 3 people, with at least one or two people from outside the board. So they're kind of a separate unit that looks at the applications for participant funding. They compare them against the criteria and the money available. Then they make the recommendations to the NEB's chief operating officer, who then makes a final decision on how much everyone will receive. If a funding is awarded, then you have to sign a contribution agreement with the NEB. And the important thing here, why I encourage people, if you're interested in it, to apply as soon as possible, is because the funds only cover expenses that occur after the contribution agreement has been signed. So if you wait till the 26th of July and you've incurred a whole bunch of expenses, you're doing research or you're collaborating, those expenses won't be eligible for the participant funding program, even if you get accepted at the July, you know, late in the summer, because you have to have the contribution agreement in place first. So it's kind of a rolling approval procedure. So when they get applications for participant funding, they're making decisions already. So if anyone is interested in participant funding, please come and talk to me a bit about that, and I can make sure you get the right forms and talk to the right people. I think my last slide is just a bit about my role in this process, in this hearing. I'm the process advisor, and my job is to try and help people understand. I think there's oftentimes a lot of frustration, and it's kind of a confusing process, and there's a lot of different steps. So my job is to try and help people understand what the process looks like, how you can participate in it. I'm available by email, telephone. At the end of the slide, I have my contact information. I have some cards here. If you want to get those, I'd be happy to give those to you. As I said, particularly for those people who are interveners in the process, then I continue to work with them to make sure they understand the different steps and, oh, here's how you do information requests, here's how you prepare your evidence. So I try and I'll work a fair bit with the interveners as the hearing progresses. Again, I can talk a lot about process matters and give you suggestions about what your different options are, but I can't really make your case. I can't take your information and pass it on to our board members who are making the decision. I'm not able to do that, nor can I take your information or comments and pass them on to Enbridge. It's really more about the process that I can talk about. And with that, the lengthy preamble, I'll turn it over to Paul, who'll talk a little bit about some of the construction and operation mandate.
Sorry, if I just,
Sure.
one question on the process. So essentially, you are doing the environmental assessment, and therefore you are replacing the role of Minister of Environment, or taking the role of Minister of Environment when it comes to pipelines. Is that my understanding of the division of labor, if you like, or jurisdiction?
Yeah, so there's a simple answer and a long answer. I suspect you'll like the long answer. Yes, so the National Energy Board, in our mandate, we have, again, we talk about safety, environmental protection, those type of things. So the expectations that we have for companies is that they need to prepare, they need to do an assessment about the environmental effects of their project. The board takes this, and we will do our own environmental impact assessment. We'll use the information that's provided from the company as the starting point. We'll ask questions about that. We'll, compare it with best practices and the information that we have, and we'll be making a determination whether there's any significant adverse environmental effects. Okay. So we do have an environmental mandate, and we make a determination on the environmental effects.
Okay, thanks.
But Enbridge actually does the environmental assessment.
Oh, that's irrelevant. I mean, it is not the Ministry of Environment, it is the National Energy Board when it comes to pipelines only. Like if it's a cement plant or something else, it would be Ministry of Environment, not here. It's like exempt from the jurisdiction of just thanks.
Okay.
So my portion assumes that the board has approved the project or a project, and this is what we do afterwards. So essentially, what the company puts in their application, they must do. Okay, so if they promise that they will do something, that they will construct it in a certain way, put this size of pump, or whatever it is, they are obligated to do it by the approval order or certificate that the company or the board puts out. On top of that, they must have complied to our regulations, the onshore pipeline regulations, 1999, which references a bunch of other technical standards like the CSA Z662 and a bunch of others. So our skinny regulations actually then balloon into big fat regulations, because the CSA document that I mentioned is something that are close to 600 pages long of technical requirements. In our approval document that we issued, there's going to be a lot of conditions. I haven't seen one yet that doesn't have conditions in there. And typical, one of the very standard ones is that they must abide by all the commitments, do use specifications, standard policies, mitigated measures, procedures that they made in their application and during the hearing, be it verbal or writing. They have to do this. And as well, the environmental assessment that they worked on, everybody worked on, that has to translate into plans. Okay, either specific conditions that would require them to do something, or environmental protection plans is a general plan that takes that information and says, for example, if they're building a new pipeline, it would tell them, all about what kind of revegetation would be required, how wide the right-of-way, how they would cross the stream, all these kinds of things. That anything that was special about that stream, for example, would have to be translated into the plans so that when they build it, they're actually following what they said they were going to do. Sorry?
Since we're not talking about a new pipeline like North Gateway, we're talking about a 38-year-old pipeline. Is anybody currently going to assess the pipe in the ground? Because Enbridge's assessment, attachment 7 of the application, clearly gives us information that Smart Pig went through it in 2006.
Let me answer that.
It's now 7 years later.
Let me answer that. The first thing is that it isn't just about the pipeline. They are going to be doing a lot of work in their stations.
I know.
So that is what I'm going to be talking about. So all this stuff really has to do with the stations, okay, in this particular example, okay? There are also requirements that might come up as a result of the assessment of their integrity assessment that they go through. Yes, it says in there somewhere that they did some Smart Pig runs and they haven't got the data back yet. That'll be dealt with during the hearing. Probably by the time that happens, it would be available.
Guaranteed during the hearing, because I know in Hamilton and Burlington, they said, yeah, we're not sure if we're going to be able to get the data there to you before.
I can't guarantee anything. It's not my application.
But it has to be in the NEB's hands.
If you could maybe tell us, did it happen for the section that's already approved by NEB?
I couldn't even tell you that. I didn't work on that one, so I can't give you the first hand. Let's assume, for an example, that they hadn't got the latest and greatest information on that. There is still a lot of information that's in that assessment, okay? Let's assume, for example, that it wasn't available, could not be available at the time of the hearing. At which point, probably the company or interveners could suggest conditions, or NEB or interveners could suggest conditions. You have the ability to do that as interveners, to say that I'd like that report filed with the board. We want a plan of action for how the defects would be dealt with. All kinds of stuff are possible. But we have to go through the hearing process first to identify what actually needs to be in that condition. They may actually have it filed by that time. I don't know. We play it by ear. They might if they determine that they actually need that information. So there is often a lot of information that isn't available in a hearing that comes later. Usually, even in a facility application for a new pipeline, the information that we're dealing with is preliminary information. The very detailed, the makings of drawings, the choosing of manufacturers, and all that stuff comes later. And the board deals with that, and the staff deal with that later.
Do we know what milepost we are in Kingston, from what to what?
I might be able to figure it out that offline here. We can maybe look at the application and see where that would be. So when the approval order is issued, we typically assign somebody in our staff to oversee the compliance verification process. The conditions are typically written in such a way that we can actually have something that we can verify. We try to write conditions that we call SMART: specific, measurable, attainable, relevant, and trackable. We don't like conditions that we can't verify that did they ever do it. So we try to design the conditions so that something tangible can be found that would show that it was done. Okay, so we have a person doing that. There's a decision made, usually in consort with the operations project manager, we call them internally, as to how many inspectors are going to be sent out and when. Usually is early in a process, we'll send somebody out, and then we're going to assess the company's performance. And if it's really, really good and it's super professional, then they'll probably get a light inspection during the project. If we see that it's a gong show, well then, we're gonna have a lot of inspection. Every company is different, there's different levels of competence out there, and we'll see what it's like when we get to that point. Now, basically after the facility is constructed, we have a process whereby the company must seek permission of the board before they can open the facilities. And this is typically involves reviewing pressure test records and other information that the company must provide so that we can say, okay, that looks like this is a safe pipeline, and this is the NEB who establishes what the maximum operating pressure of the line is at that moment. And it stays like that until the board changes it. Now, the other thing too, sorry, I have a...
Because this is a line reversal, not a new pipeline, will there be pressure tests required?
That would depend on the assessment of the application and what the board determines might be necessary. If it's necessary to pressure test, they will. However, I know that typically you can get a lot of very good information from those smart pigs that go through the line. The thing is with the hydro test is that it'll blow up if, say, something happened or if it doesn't burst but something else is there. You don't really know what the other parts of the line are happening. You don't get any information other than the fact that it managed to hold it at that pressure. With the instrumented pig, when you put it through the line, what you get is readings. These things have lots of information. They take readings like every inch, all the way along 360 degrees as to how much corrosion there is, how deep it is, and the whole bit, all the way along.
I know, it reported 3 times on the Kalamazoo split before it split, and they never fixed it. So, will you be requiring as part of your process the smart pig information, even if an intervener doesn't ask for it? And
well, we're operating separate. We're operating separate. The staff, the NEB, asks its own questions and uses its own expertise to challenge the evidence of the company, and interveners in the process can ask those similar or other questions. It's really wide open.
Yeah, my specific concern is will the staff of the NEB be reviewing the smart pig data before the pipeline's turned off?
And as I said earlier, maybe it depends on whether it's available or not. And if it wasn't available at the time of the hearing, it is possible then they could ask for it to be available as per a condition later on, so they can ensure that whatever needs to be fixed gets fixed. Now, when these companies supply information as per a condition, it's typically actually posted on the NEB website in our repository. So pretty much everything, unless it's secret, there are secret processes sometimes and whatever that they'll ask for permission to keep it confidential. But I would say like 99% of what's submitted is completely viewable by everybody. So the openness...
Big data is not secret?
Pardon?
Is big data secret?
Well, it may or may not be. It's up to the company to apply under section 16.1 and demonstrate to the board that why they shouldn't, the board shouldn't require them to be available. Now, I'll give you an example. I was on a hearing where somebody asked for the company's engineering specifications. And they said, well, that's fine, but that's worth a lot of money to us. We don't want Joe Blow Pipeline to come in and then just use our specs and not have to develop them ourselves. We put in a lot of effort to develop our specifications. We hired experts to help us design these things. Why should we give it away for free, right? So that's an example of an instance where somebody makes an appeal like that.
I can appreciate that, and I can appreciate why the company would want to keep that information secret. I can't, for the life of me, dream up a reason why they'd want to keep big data secret unless...
I don't know the reason either. I don't know the reason either, but I'm just saying that that's a possibility.
Has big data been put up on the website in the past?
Not that I am aware of.
Could Gavin, let's say an intervener were to make a case for requiring that pig data as part of the hearing process, and to require that it be released during the hearing.
Sure. And one thing I know about on the Enbridge Line 9 Phase 1 portion, that question did come up, and the board, again, it was a different panel, but the board did attach a condition onto the hearing that they had to conduct a bunch of inline inspection runs, they had to conduct a bunch of integrity digs, and I don't think they required that they had to submit a specific result, but they had to provide a summary of the results, and they had to provide a summary of basically a discussion of what these results mean and how these results demonstrated that the pipe was fit for service. So it didn't give, like, I don't think the condition included the detailed data from those runs, but it asked them to file that publicly with the board, the summary data, and a discussion of how this demonstrated that the Phase 1 portion was safe. So that is an example there where there was concerns, the board was convinced in that case that this should be public and people should have an opportunity to see it, and so they attached a condition. And I don't think that, you can see what the wording of the condition looks like, but they haven't got to the point yet where they've finished all of that, so you can't see, there's not an example, I guess, of what it looks like, but that will be filed and it will be public.
I'm trying to figure out who delegates their data.
Yeah, exactly. Enbridge does the tests on their
So
own
they do-
stuff
So they, yeah.
and
so-
submit the data.
It's completely self-reporting.
It's actually, no pipeline company owns their own pig typically. It's contracted out to specialist companies who own the pigs. And they have specialists who run the pigs in the pipeline and then process the data and provide reports to the company
That
saying.
Enbridge pays for.
Oh yeah, well,
They
somebody's
pay-
gotta pay
yeah,
for it.
So they pay for
But,
that.
and so they get a report like everybody else, like, and then it says, in these locations, this is the kind of defect there might be, and they'll identify the ones that need to be repaired right away. Some of them are still benign. Just because you have a pit that's, say, on a pipeline, doesn't mean necessarily that would be considered a defect yet, right? Because if a shallow, very, very shallow pit doesn't mean anything to the pipeline. It can operate no problem.
Yeah, I mean, I don't know that
Yeah.
aspect of it.
And that they identify which ones typically must be repaired, and then that's where they go and do their digs and put typically sleeves on top of that pit to reinforce the pipeline.
How often are
But
they?
the problem is that it's all run by Enbridge, they analyze and they then do the fixing, and I think what people are trying to get the idea is why would we trust the company to do their own maintenance and that
Well,
sort
they
of
own
thing?
they own the pipeline, right? And it's their asset. Just like we trust you that you will make sure that your car is running right.
No,
Because it's
we
yours,
do a test.
but you know what I mean? But that's the thing, is that the government isn't Big Brother in a way that we're gonna go and see everything and we're gonna tell them, no, you do this one and you do that one. They have a responsibility, it's their company, it's their assets. They have a responsibility to maintain their pipeline.
Excuse me, just related.
He's been, has a hand up.
I have a question, I think we're getting off on those tangents.
Yes.
You're talking about trusting the company, but I feel I'm a little confused. The question I have is, before they get approval of this, do they have to give that information? Like, I get the feeling that they don't, and I think that's a problem, whether or not it's their information or somebody else's information, because you got experts in that, that can look at them, and hopefully we can give you the benefit of the doubt to a certain extent there. So that's the question I'm having here is, will you approve it if you don't have that sufficient information?
Well, you're asking me to say what the board member would do,
Well,
right?
it
I mean,
seems
I'm
to
just
me you
saying,
have
as
to
I'm
have
saying, and I've said
information
before
before you can
actually,
approve something.
is that during the course of the review, they might look at it and say, oh, we really would like to have this data, right? Before the reversal happens. It wasn't available for whatever reason at the time of the hearing. They might put a condition in, just as Michael described, and say, we want this report submitted before this happens, and they'll put a date on it, right? And say, we want this information so that we can then verify that the company has done all the work required to repair all the defects that are identified in that report. I mean, that's what conditions are for.
Don't they have to know what the pipe looks like before they can approve it or not approve it?
Well, again, that.
I mean, looks like, I don't mean like I dig it up and look at it, but.
Yeah, well, the thing too is that they've done dozens of pig runs over the years. And one thing is that defects don't grow like
Well,
super
that's-
fast,
that's
right?
what I'm
They,
asking.
they're not really very fast growing. We're talking, not even a millimeter kind of thing, every few years, and that's really pushing it. I mean, these things don't go that fast.
So you do have that information, you just maybe not.
And it could be asked, all the stuff from
That's
even 5
basically
years
what I'm
ago
asking.
could be looked at. But we're getting off topic here. Maybe I could answer a lot of these questions when I'm done.
I'm just wondering why we always focus on the inside of the pipe and not the outside of the pipe. Kalamazoo was the outside of the pipe. Kalamazoo was a crack field that the pig did not know was there. Because the crack,
I understood differently.
It was
I
a-
understood
it was
this
a
off
crack-
in 2003.
it was a, well, no, there were other problems. But there was a crack field that was not deep enough for the pig to pick up. That's where it burst.
That's
So
not
they could
improvement.
have the most current data on the inside of the pipe. The problem happened because the polyethylene tape pulled away from the pipe, the water got underneath it, it sat there, it's steel, it rusts, and it blew up. And that was very, very, very minimal cracks that they spider webbed and created a soft spot.
Okay, so I'll try to answer some of the issues I heard in that. Okay, first of all, the reason why we talk about the inside of the pipe, these pegs, is that these pegs allow you to actually measure things throughout the wall of the pipe. It'll actually tell you what's on the outside, right? It doesn't matter that the peg is on the inside. It'll tell you if there's corrosion on the inside or on the outside. Doesn't matter. They have pigs that can find cracks. They have pigs that can find dents. There's all kinds of very specialized pigs out there. Okay, so that is one thing. Now the Kalamazoo thing, that was an SCC incident, stress corrosion cracking. That's questions that people can ask Enbridge during the hearing, right, and explore what kind of data they've got on that. What have they done? All those things like that,
But
right?
the question is whether Enbridge is capable of providing information to you so that you can decide properly. Whether or not, can the pig tell if the tape has decomposed and come away from the pipe?
It's actually,
That is
we
the
can,
coding.
I think the better way to do it is assume that it came off everywhere.
Exactly.
And because the tape isn't really the story, right? The tape, like the corrosion, like I'll go back here, I'll give you the thing is that when you put a pipe in the ground, it's steel. Obviously, steel can corrode in a wet environment like that. So the first thing you try to do is you put a coating on it that will be isolate the metal from the environment. Okay, that's the first thing. Your primary safety feature, right? Good coating. The second line of defense, if you will, is called cathodic protection. So they essentially make the pipe a cathode by running electricity through the ground. And where there's a defect in the coating, the pipe won't rust there because it's a cathode, it's not an anode in the chemical system. Okay? So essentially, it's basically covered. Okay? Now the problem with tape-coated pipe, right? It was thought to be a great idea in the 70s and all that good stuff. But the problem with the tape-coated pipe is that it would disbond and water would get underneath and the cathodic protection couldn't get underneath there to protect the pipe like it normally would if it was just like scratched like that, like, so the coating was damaged. You can't get in there and go long, so to speak. That's what its problem is, okay? So normally, you would say that in a normal new pipeline, they don't use tape anymore, right? So you get this pipeline, you coat it with epoxy or something like that. You don't really have to worry about SCC and all these things, because even the way they put the coating on actually helps prevent SCC from happening. Now, in this case, We don't have the ideal world, the ideal material here. We have a pipeline that has that tape-coated pipe on it. And that will obviously be an issue to look at during the hearing. Right, and that's all I could really say about that. I'm not even on the project, so I mean, I'm not even doing this for that. But I can tell you that it's an obvious.
I think, yes, it is, thank you. I think the general consensus, though, is that we are dealing with a pipe that used to be a 1/4 inch thick in 1976. It was wrapped in tape. We know fully well, as you say, tape is not the best coating in the world, it doesn't get used anymore. Okay?
It's still a 1/4 inch thick.
If we are to believe our pipeline at 38 years old is completely safe and we should be comfortable with it in everyone's backyards, then why are the standards so different for the Northern Gateway? Why is the pipe so much thicker? The minimum is 0.4, up to 0.78
.78 what?
of an inch.
The reason that, I'm on that project, so I could tell you that
So
one.
thank you, yay! So we're talking a 1/2 to 3/4 of an inch.
And essentially, that's because when you're designing a pipeline hydraulically, you can make decisions about how much flow I want to put through that pipeline. And you can look at it and say, higher pressure pipeline, I can put more oil through the line. So they increase the pressure, they increase the wall thickness, direct relationship.
Are they nervous? Is that why the pressure doesn't go up?
Pressure?
They're not increasing the pressure, they keep.
No, well, they don't need to. They can put that drag reducing agent in there, which in my understanding is like a little bit like ethylene glycol, and it calms turbulence in the pipeline and allows them to flow better.
And has carcinogenic chemicals.
Well, you can ask questions about that too if you like.
I'll just encourage
I'd
all
like
to
to get on
go
today.
through because I think in the when we talk a bit about operations, you'll see how what the NEB does for oversight during the operations phase. Maybe that's helpful for some of your questions.
Okay. I think we have all this covered. So during operations, we undertake a lot of activities, inspections, audits, and what have you. But we use a risk-informed approach to compliance activities. Because the thing is, we have over 70,000 kilometers of pipeline, hundreds and hundreds of facilities, and we just don't have enough people to go there every year, every month, or whatever you think might be adequate. So we have a kind of a semi-quantitative approach to it where we try to take into account what the product is on the inside, who could be hurt, what could be damaged environmentally, and we also take into account the compliance record of the company as observed by our inspectors during other inspection activities. So we kind of have scorecards, if you will. And so we determine, based on that, a kind of a pecking order as to which ones, relative to the others, are riskier and what is the lower risk. And then we create a plan to verify whatever needs to be verified in that particular year. Okay, so that's how we kind of approach that system. But we also know that for, say, construction-related activities, it's not really easily planned. Because often we can have a project that's approved in May and they're constructing in September, but you made your plans in April and you really don't know yet. So we have what we call them demand activities. So we have a portion of our plans are more flexible. So we have our planned plans and we have our unplanned activities that we undertake during the year. But basically all the companies get some kind of oversight at some point during the year. And where necessary, some get a lot of oversight. And I mentioned before what kind of activities we do. We do all kinds of inspections, safety, pipeline integrity, environmental security, crossings. We attend emergency exercises where they actually practice their emergency plans. And we review their plans in-house. We also look at post-construction environmental reports, so we might go out in the field and verify, because often we'll put a condition that says that you have to tell us how the remediation is happening on this particular project. We'll go out there and ground truth some of these things to see how good it was. We also have compliance meetings, which are like a bit of like a meeting with the company, where we ask them a lot of questions about how they do things. In essence, though, we're really getting a feel for whether we think these guys are needing to have more inspections or audits or something like that. And then we have our full audits that we do. Now, our audits are based on reviewing a management system. Okay, so we expect companies to have a management system and that they have a bunch of programs that are set out in the regulations. We have environmental protection program, emergency preparedness, damage prevention, integrity, security, and a safety program. The safety one being more OSH related. And so the management system, essentially we require the companies to have policies, procedures, plans, that they have to have their whole organization built around trying to comply and to make these plans successful. And it's all based on a plan, review, do, and learn approach, so that they're always supposed to be verifying, did we get good results on what we did last year? And if we didn't, how do we change our procedures so we get better results? So they're supposed to do a cycle like that. And we strongly believe that if you're doing this kind of an approach, you have better results in the end. And we audit companies, we choose certain companies to do these kind of audits. And they're very, very invasive. Okay, it takes weeks and weeks and weeks to do. We talk from the vice president down to the guy pulling the wrench in the field, trying to verify that everything they say they did, whether this guy's supposed to have training, did you get training? What training did you have? When did you get it? Those kind of things like that. We audit them very completely, and we produce a report, and then we submit that to the company, and the company must submit a corrective action plan on everything we found that was out of compliance or could be improved. And then we verify that.
Question. The Kalamazoo report on Enbridge's safety was very damning on precisely this. Did that result in any change or any increase in the frequency or intensity of NEB's review of Enbridge?
We did.
It's only been out for 6 months.
Yeah, well, remember they operate in the States as a different regulatory environment. Okay, they're very much prescriptive in their approach. I'll give you an example, say for this pigging thing everybody wants to talk about. So in the States, you have to identify where your where your high consequence areas are. And then from there, the regulations will say something like, you shall run this pig every 5 years, right, in these high consequence areas. In the north of the border, we'll look at it in a bit differently, and we'll say that you have to have an integrity management program, and that you have to identify and rate your own pipelines as to what the hazards might be, and you will decide which pipelines need to be inspected by what instrument, and you have to be able to be in a position to justify to the NEB when we do audits as to whether that frequency was adequate. And I believe it's better in that way, because you can have pipelines that are, say, the Northern Gateway, let's pretend it's built. I mean, it's got the best coating, it's got a thick pipe and everything. And if you're running a pig on a perfectly good line every 5 years, it's quite a waste. Because really, you wouldn't expect it to corrode or do anything for quite a while. But there might be other pipelines where the coating, like they have a lot of issues on this pipeline. Maybe you don't want it to run every 5 years. Maybe you want it to run every 5 or 3 years, because it needs every 3 years.
It appears to be every 2 on line 6.
Well, then they must think that line 6 really needs it, right? But in the U.S. world, they would only have to do it every 5 years. Okay, so there's more flexibility. The flexibility allows them to do the right thing, in a way.
So would they submit to you, for example, their cleanup protocol?
Well, as I said, this is not my level of expertise for cleanups, okay? But my understanding is that they're basically, a cleanup is designed based on what you have in the field when it happens. Okay, they have a plan that will say how we react, and this is where all our materials are, and they'll practice putting booms out in creeks and all kinds of stuff like that. But if you had an actual incident, okay, there will be involvement of the government, and the company, whoever that may be, involved in making decisions as to how we actually gonna, what's the plan for recovering the environment or
Well, I guess
whatever.
what I'm saying is, do they have to submit that plan to you in advance?
Well, the board will be, well, they'll be submitting it to the government and NEB. NEB, there's gonna be provincial guys there, federal guys there, all kinds of people. It's a very active process.
Because they have quite publicly refused to change their cleanup protocol even after the spill at Kalamazoo, even though the oil reacted far, far differently than conventional oil does.
Again, I'm not on this particular file, but we'll take their word for it, I guess.
Can I just ask?
Yes.
Is that something that an intervener would be able to?
You can question on emergency response plan. They obviously have one now because they have an operating pipeline. So the question is, what changes do you have to do, I suppose, to your emergency response plan in view of the fact that you're going to have potentially dill bit in this line and things like that, right? These are all questions you can ask and ask them for responses to these questions, right?
Just a little question. If I'm monitoring my own well, and I'm noticing, let's say, this goes through, and I start monitoring one of the chemicals which are coming in, and I see a spike, but it hasn't reached an exceedance yet, but I feel like there's some ill effects on my family. What would be my steps? Like, would I consult you? Would I consult Enbridge? Like,
Well, I would, usually when you have this kind of situation, my understanding is the first people to complain about this issue would be the company, because they're directly, in a way, they're gonna be able to do some check to see if they can agree or not. They're gonna be able to presumably have damages or whatnot. It's usually you go over to the NEB when things aren't working out, right? So we can get in there and because I'll tell you, when we have a landowner complaint, usually what happens is they say, the first questions will be, so did you contact the company? What did they say? Right? Well, if you never went, then you can't really, you're right away, you're gonna be in a process where the NEB is gonna start asking Enbridge, so-and-so has an issue with their well, they claim they have health effects, have you done this, whatever. So the process always involves the company because they're part of the circle, so to speak, right in the incident. So again, finally we get to abandonment, which is my last slide, I believe. So before a company can abandon a pipeline, it must apply to the NEB. It's in the Act. And it says that you have to have a public hearing for an abandonment. And the board will consider safety, security, environmental protection, economics and finance, the rights and interests of those affected. The board has been seized with the abandonment issue for quite a few years now, because obviously one of the things that people bring up is that, well, if you're really down the road to abandonment, is even the company going to be viable enough to actually do whatever they need to do, right? Are they going to have any money? So the board has been looking at that and working on the idea that eventually what will happen is that the companies will have to be setting aside certain amounts of money to be able to cover the abandonment of the pipeline. And how much exactly has been part of hearings right now that have recently occurred. I'm not on that file either, there's lots of files. But they have been looking at this and trying to see how much money they would need the company to accumulate and how it would be set aside and the whole 9 yards. But all these things are really pretty much determined on a case-by-case basis, right? A pipeline abandoned in the far north will be completely different than one abandoned in somebody's field outside of town here somewhere. So you have to look at the particulars of everything before you make a decision, and usually everything has to be done before the board will actually abandon the line. So this all has pre-abandonment conditions, or what's in these orders. Because once it's abandoned, actually, technically the board has no longer jurisdiction. So they can't actually enforce it. So we make everything so that we can make sure that the pipeline has been cleaned or removed where it needs to be removed or capped or whatever needs to happen. It's all done prior to the actual abandonment phase of the project. And that's up to the company to pay for all that. So I believe that is it for me. So if there's other now
I
questions.
have a question. When you mentioned abandonment, is there, like you are the file for a new pipeline, when the pipeline construction is approved initially, is there something like expected lifetime of the pipeline that is specified?
Not really. Essentially because the pipeline that's properly maintained can last, I mean, there are pipelines out there that are 70, 80 years old and still running, okay? Typically though, you'll hear a number like 30 years or 25 years or some number like that. Really what that's tied to is depreciation. They want to make sure that by the time that the resource, let's say, that they're moving from A to B has been used up, that the pipeline's all paid for. So they'll talk about a life of 25, 30 years or something like that. It's shorter actually, say if you go into the oil fields and gas fields, there are very limited pools, right? They won't run for 30 years. They might get 10 years before they run out of gas in that pool. So you basically have to have paid it off in the amount of time it will take to empty that reservoir.
Just a comment on that. Frank Cheng, who is the Canadian Research Chair for Pipeline Engineering at the University of Calgary, you may know him, Ashley, you're from out there. He says that it's not really an economic issue, it's more a matter that the coatings he predicts are going to start breaking down at about the 40-year point, and that indeed you're going to get some external corrosion, whether you're cathodizing them or not. So it isn't just an economic issue, it's also...
No, they're actually, as I understand it, Enbridge is completely replacing that line 6A in that resulted from that had that Kalamazoo incident. They've decided, they've actually discussed this in the Gateway hearing where they...
I wasn't really talking about Kalamazoo.
But in that case, what I'm getting at is that they thought about what they would have to do in the future on that particular line. And they decided that in that case they needed it. It was more economical for them to replace it completely than to try to put as much money they thought that would be needed to keep the old line going.
Yeah, their line happens to be just
The exact same line, except they were about 6 years apart. Same diameter, same grade, same problem.
So you can have at her in the hearing if you want.
Just
But
one more question if I could though. Do you have any kind of role with the local conservation authorities? Because those guys could be, in my mind, a real company for them to do a real resource with the eyes and ears on the ground. They're responsible for the water in our municipalities. Do you talk to them? Because when I talked to ours, they weren't even sure exactly where the line crossed the Trent River.
Where what?
Where the line crossed the Trent River. I talked to the Trent Valley Conservation Authority. The guy did send me a link to a map, but they haven't talked to much about it. So I'm assuming that they're not talking much to the local conservation authority. Is that correct?
I'm not sure what type of, maybe we have all sorts of, I'm not sure, I have no idea who Enbridge is talking to. For this application, I think there are some particular provincial permits they need, whether there's any from the conservation authorities. And
but there is a systematic passage of information to the conservation authorities.
I know for us, I'd say we tend to coordinate more with the federal government. I know in our own, whether it's environmental issues, we're working with Environment Canada and Health Canada and Department of Fisheries, and so we tend to be siloed a bit more on the federal versus provincial level. And anyone who wants to leave, you're welcome to leave, but you're also welcome to stay. so don't feel you have to leave that day. But yeah, so now we can go to questions. Go ahead.
Yeah, I'm kind of just gonna save you a few questions for the end, so.
Sure.
Sure. First off, I just sort of wanted to know a little more about the end of pipe if there was a change. I know currently Enbridge is claiming that it is going to end at the Ultramar and Sunflower refineries in Montreal area. But we are concerned that they will revert back to their 2008 Trailblazer plan and connect that to the Portland-Montreal pipeline. If they change that, and Enbridge has along the way, and I know you can't speak to Enbridge, but has sort of changed little bit by little bit in every application. If they do alter that and decide they want to connect it, what is NEB's powers? I'm just trying to get an idea of your teeth in terms of, can you revoke your permission and reevaluate the entire project at that time if that's proposed?
So we do, I mean, we have to treat each project on its own merits. So each project that comes, each application that comes before us, the board members have to respond to that application. And so, for sure, in the phase one, it was a big issue, and while they're project splitting, and it's not really this project by itself. And so the board, the panel, who made that decision, they had to be satisfied that that project was a project by itself, and it met the tests that they needed. So now you see the second portion of this. And so again, this panel will have to be satisfied that this is a project that can stand on its own merits. I haven't seen anything, Enbridge definitely hasn't applied for anything to go further. I think they've always said that in the past that the Trailbreaker fell apart because there was no commercial support, so no one was willing to pay to build the pipeline. So in this one, it is the refinery in Montreal and the refinery in NEB that are supporting it, so that's where the commercial support is from. So I have no idea about those commercial.
So once it's through, there's no going back if Enbridge approves an amendment.
Well, it wouldn't be amendment. It would have to be So they would get approval to Montreal as they applied for, and if they wanted to go further, they'd have to come back with a full application for something further.
And then just getting back to the team of the NEB, I've heard in sort of the audience today too, that the language that the NEB is using, it is very much as if it is already approved or it's already decided that it's going to go through. So has the NEB actually ever denied a pipeline? Have they ever firmly said no to anything? Do you have teeth? And in what case, and on what grounds has that previously happened?
Yeah, so we have turned down applications before. We've turned down a variety. We don't turn down a lot. I think there's maybe 6 or 10 or some, not very many. Some large ones. A power line that was built.
One was a local.
A
local pipeline project. TransCanada was built across 1,000 islands to bring gas to New York State. Yes. And that project was denied by one of the years. Yeah, I worked on that.
So there is
hotels. So my brother probably argued.
So there are examples where it's turned down. Just recently this year, TransCanada applied for one and we approved half of it and we turned down the other half of it. That one was for financial matters. The one I was looking at in Sumas in BC, that was for environmental matters. So there are some examples. The other way to look at it is there's a yes and there's a no, but there's a big in-between area with what are the terms and conditions under which this project can go ahead. So I can't think of any projects that come to the board that don't get conditions attached to them. And if the board members have concerns and they're convinced by the evidence that's in front of them that there are concerns around safety or environmental protection, they'll attach conditions to them. So they'll have different steps that the company has to meet and different things that the company has to file. So it's an approval, but it's a conditional approval.
That's great. I just wanted to bring some of those examples up that people could review and take a look at. Final question. I promise. Well, maybe not, but final question for now. There's been a lot of discussion and a lot of environmental groups such as the NRDC and Defense have brought up studies on dilbit showing that it has an increased amount of corrosivity and acidity that we're concerned about when putting a pipeline. Enbridge has, of course, disputed that. I know that's out of the NEB realms. The Minister of Energy, speaking to a TransCanada proposed line just a few days ago, also gave note that still it's not more corrosive, but it's actually the fact that the Arkansas line was old, not that much older than Line 9. So there is an EPA review coming out to finalize this sort of wish-wash scientific research that has been passed back and forth between environmental groups and Enbridge. Can an intervener or through a letter of comment request that the NEB hold off on making a decision until that report is out? It should not be out until the end of the summer 2013. Is that something that if somebody asks for as an intervener, would the board consider that?
Definitely, you can ask for it. They'll consider it. Whether they, is that the report that I thought it was July, it was kind of July 2013 that it was supposed to come out, or?
I heard in some documents that it was August 2013 that it was prepared to release, but I could be wrong, it could be July.
Yeah, I mean, definitely can request that, and, you know, whether it is to, you know, I'd say there's different ways to delay the hearing you could file a motion to, let's delay the hearing until this report comes out. You can also look at it from the condition side of things. Let's condition, if you're gonna go ahead and the report isn't out, try and get a condition or something there that would include a review of it, or somehow, there might be different ways to go about it.
But new information wouldn't spike a new ability for people to then become involved in the process. So
No.
anyone who's foreseeing this report, bringing any new information should get in the process now. They won't have an opportunity to later.
Yeah. There were a couple, I had a couple notes too about the Aboriginal side of things.
Yeah.
You had asked about that, right?
Yeah, I did want to know, I noticed you reference it a lot that, you know, something that's there anyway in the NEB's kind of mandate as they talking about. I was just wondering, realistically then I see that it's there in theory, but like can you speak to Tyananega, it's right down the road here, have they had a night like this? Has the NEB been that territory and kind of publicized what's
So
going
on the Aboriginal side, we have, our process is kind of similar where this is more the public side, but on the Aboriginal side, when we get a project description filed, that general one, typically what we do is we do our own assessment of where the project is and what Aboriginal groups have asserted traditional territory in that area. So we identify, we create our own list. We look at who the project contact as well, but we develop our own list and we send out letters to all those groups that have asserted traditional territory in the area. We'd follow up that letter with a phone call, asking them if they're aware of the project, and more importantly, asking them if they're aware about the NEB and the NEB process. And then, so they would, you know, through talking to them on the phone, we would see if they're interested in having a session like this.
So who would you talk to?
In the actual...
In the communities, I mean, who's your point of contact? Is that the band council, or?
Yeah, and it would depend on the communities, but it would be at that level.